Going live. Good morning, everyone, on this webinar. Today's webinar is on judgment writing. It's a continuation from yesterday's webinar. So yesterday we had Pradeep Justice Nandrajog sir for the session, and he'll be taking this session today as well. Today, in this session, I have with me, Nasir Hussain Jamadar sir, who's the additional director of Jammu Maharashtra Judicial Academy. He'll be helping us during this session, and he'll be the moderator. Like any other session that we've been conducting, there'll be a question answer round in the last. We'll be opening the question answer round for 15 minutes. Once the Lordship says that he's going to take questions. In that 15 minutes, I would request everyone to put in your questions, and post 15 minutes, we will close the question answer round. I would now request Nasir Hussain Jamadar sir to please welcome Nandrajog sir, and Nandrajog sir can then start the session. Sir, please, Nasir Hussain sir.
Yes. Thank you, Chetan.
Yeah.
I welcome my Lord Honorable Shri Justice Pradeep Nandrajog, former Chief Justice of Rajasthan High Court and Bombay High Court, on behalf of the Maharashtra Judicial Academy and the participants for today's webinar on judgment writing. Also welcome all the Honorable Lordships, Registrars, Principal District Judges, brother and sister judges, heads of the judicial academies across the country, honorable judges from Sri Lanka and Kenya. I am skipping the formal introduction as directed by His Lordship so as to give more time for today's subject. Now, without taking much time, may I request Honorable Lordship to start today's session. Please, my Lord.
Good morning, everybody. The topic is a little dry, so I wouldn't be anecdotal at all. It's judgment writing. Now, a judgment, as we all know, generically, is a formal law-based decision when we refer to a judgment in a court of law. It is distinct from the mundane judgments which we take by way of judging things. You go to the market to buy cloth for a shirt. We look at various kinds of fibers, textures, and take a decision. Well, I'll go in for this colored and this cloth. It's a decision, it's a judgment, but it's a judgment personal to oneself, and society or third parties are not affected by these kinds of judgments. There would be an element of subjectivity in the kinds of judgments which we take on daily basis. But when it comes to a judicious decision, a judgment in that context, there are some parameters which require to be followed. As I've been repeatedly saying, to know a legal norm and to understand the width and the length of a legal norm as well as its height, that is to understand it in its three dimensions, the reason behind the legal norm needs to be understood. For only when we understand the legal norm behind, the principle behind a legal norm, the jurisprudence of the legal norm would be understand what the norm is. In that context, we would find that the jural norm governing a judgment is that it tells the litigating parties why the case was decided by a judge in the way it has been decided. The physical manifestations of these forms would be that it should show that the judge has understood the rival cases presented in the pleadings of the two parties. The judge has correctly picked up the issues of fact and of law which need to be decided. The judge has analyzed the evidence by compartmentalizing the various facets of the evidence. The judge has then determined whether a fact was proved or not proved. The judge has considered whether a fact which is proved was relevant, and if relevant, what would be the weightage to be given to the relevant fact found to be proved. Then has he compartmentalized and bundled all the pros and cons of the facts which tend to probabilize an event, facts which tend to deprobabilize an event, and then extracted from this molten liquid the concentrate from which the crystals which finally the judge takes out. All this can be put in an extremely simple sentence which would bring out the three facets of a judgment. The simple sentence is, these facts viewed in the context of this law lead to this conclusion. As simple as that. So the three elements are, first, these facts. Second element, viewed in the context of this law. Third, lead to the conclusion. So see, if we reduce something to its concentrated level, we find that it becomes extremely easy to understand. So therefore, every judge or any person who has to give a written opinion for some time right opposite his table, and I did it when I became a judge, lest I forget it. So I always wrote and looked at it. What am I to do while writing a judgment? These facts viewed in the context of this law lead to this conclusion. You know, there is a Commonwealth Judicial Academy in Halifax in Canada. They have been conducting training courses for justices through law professors in the art of judgment writing. And I have a printout of a dialogue which a judge had with a professor of law who had specialized into the art of judgment writing. The judge read the judgment delivered by this judge, and next day morning had a dialogue with him when everybody was having breakfast together. The professor told the judge that I had trouble figuring out what was the case till I reached the 15th page of your judgment. So the judge looked at the professor and said, "Yes, professor, I can see that. Well, to tell you the truth, even I never knew what was an issue till I dictated my judgment till the 15th page." So that was a very, very frank admission. And regretfully, most of us also fall in that category. Now, the structure of a judgment, as I said, is in three parts broadly with subheads. These facts, viewed in the context of this law, lead to this conclusion. Now, let's pick on these facts. Now, when we refer to these facts, they have to be the facts in dispute which emerge from the pleadings of the parties. So the first part of the judgment is, what is the rival case presented in the plaint, written statement, replication, and so on. Here, I would like to posit a comment. Never pick up a plaint and start dictating the plaintiff's case, followed by picking up the written statement by presenting the defendant's case. This would require us to understand that all pleadings do not form a homogeneous, uniform class. Pleadings fall in four distinct categories, and unfortunately what I am noticing is that large number of lawyers and large number of judges do not keep into account that pleadings can fall in four categories. Like this. The plaint is an assertion of a claim by the plaintiff. The response to this assertion of claim by the plaintiff by the defendant can be category 1, a general traverse. He denies every fact pleaded in the plaint and thereby makes an issue of every fact. This plaint, this written statement to the plaint, does not require any replication. Why? Because the defendant has made a general traverse. He's denied every assertion made in the plaint. It doesn't need a replication because the replication would be nothing but a reiteration of the plaint. So dear brother and sister judges, start controlling your judgment writing at the stage when the pleadings are being made. If the written statement is a general traverse, stop the pleadings there and then. Second kind of pleading could be where the defendant makes a special traverse. What is that special traverse? The special traverse would be, just a moment, I think the link has gone. Can you hear me?
So we can hear you.
I thought the link is gone. Okay, sorry. From my side, the screen went off blank. Right. So in the second category of the pleadings would be that the defendant makes a special traverse. What does a special traverse means? Certain facts and assertions in the plaint he admits, certain assertions of fact in the plaint he denies. So the distinction between the general traverse and the special traverse is that in the special traverse, he makes an issue of some of the facts. In a general traverse, he makes an issue of all the facts. So such kind of a written statement also does not require a replication. Third, he makes a plea of demur. What is a plea of demur? He doesn't traverse any fact pleaded in the plaint. He simply says, take all these facts as true. Still in law, the plaintiff is not entitled to a decree. This written statement also does not require any replication because the defendant has not made a traverse of any fact. He's admitted all the facts. The difference in these three kinds of pleadings would be that in the first kind of case and the second kind of case where there is a general traverse and a special traverse, the fact at which the parties are at variance, that is the fact in issue, emerges there and then. It could be one fact in issue, it could be two facts in issue, it could be three facts in issue, it could be 10 facts in issue, but the facts in issue emerge there and then, and they can be settled in the issues. If it is a case of a demur, no issue of fact arises. Only an issue in law would arise that whether on these facts treating them to be true, is the plaintiff entitled to a decree. Such a case would require a pleading not to be followed by the settlement of the issue, no evidence. Why? Because no issue of fact has been raised. The fourth kind is a little problematic and generally takes place, and this is here where the judges have to be careful. The fourth kind of a written statement is where the defendant makes a plea of confession, full or in part, followed by a plea of avoidance, meaning thereby the defendant admits full or some facts pleaded in the plaint, that is the plea of confession, followed by an avoidance. What is avoidance? He puts forth some further counter facts to nullify the claim of the plaintiff. Now, it is only this category of pleading which requires a replication, because law says a fact asserted and a fact denied gives birth to a fact in issue. Now, in this case, since this written statement, where a plea of confession is followed by a plea of avoidance, the fact in dispute has not emerged till the plaintiff files the replication. He then deals with the new facts introduced by the defendant. And do not forget that in law, the plaintiff is entitled to respond to the written statement in the same four manners in which the defendant is entitled to the plaint. So the replication can make a general traverse of the facts of avoidance pleaded in the written statement. He could make a special traverse. If he makes a general and a special traverse, parties are now at idem on at what fact they are in dispute. He could make a demur, no further pleading, but then he in turn in the replication could make a plea of confession with avoidance. Now this avoidance followed by the confession in the replication would require a sur rejoinder by the plaintiff. Why? Because pleadings have to be contracted till the stage where the parties are at variance on a fact in issue. The third one, and let me illustrate because illustrations make one understand the theory. Mr. Jamdar, there is too much of movement in your room which is distracting me. There are too many people walking in, they are distracting me, please. Now, let us take a case where the plaintiff in the plaint states that I am a hardware merchant, the defendant is a petty contractor. As a petty contractor, the defendant purchases from the plaintiff's shop such material which a hardware shop sells and are required by petty contractor, such as latches, nuts, bolts, paints, primers, sandpapers, cloth, brushes, nails, etc. And he says that as per the oral understanding between the plaintiff and the defendant, I supply goods at a credit for the entire duration of the month. On the first day of the next month, we settle and square up the account, and the defendant issues a check to me to clear the value of the goods, the price of the goods which he has lifted in the previous month. And then he says that for the month of March 2020, on the 1st of April, we settled the accounts, 1 lakh was due and payable, and the defendant issued from his account a check number so and so in sum of rupees 1 lakh payable to me. When presented for payment, it was returned dishonored by the banker of the defendant with the advice insufficient funds, and hence the claim for rupees 1 lakh with interest as per the Negotiable Instruments Act at 18% per annum. The defendant files the written statement. He says, I admit that the plaintiff is a hardware merchant. I admit that I'm a petty contractor. I also admit that there was an oral understanding between the parties that I used to pick up goods from his shop from the first till the end of the month. I also admit that on the first day of the next month, we used to sit and settle the accounts. So these are all pleas of admission up till now. Then he sets up the plea of avoidance. Now he says, this check I had issued as a blank check to the plaintiff when we started our business transactions 2 years back. He said I gave it as a blank check because the plaintiff wanted it as a security, and then says that the check leaves from my checkbook containing 50 checks issued by the bank were issued by me in these names on these dates, which were much prior to the month of April 2020. Then he says that in the month of March, the plaintiff had told me to do painting and polishing work in his house. And the labor rate agreed was that for every painter, he would pay me 500 rupees a day, and for unskilled labor, 300 rupees a day. I had deputed 3 painters and 6 unskilled labor to his house, and the work took full 20 days. Then he says that the material which I had picked up from the plaintiff's shop to be consumed in the plaintiff's house, to my shock, was entered by the plaintiff in the account maintained by him of delivery of goods to me for my use. So I told the plaintiff that, look, this material, though I picked up from you, I had used it in your house. So you can't bill me for this. Then he says that during the course of the work, certain woodwork had to be executed because the ply of certain doors had become rotten. So I bought some plywood and I used that. And then he says that while settling the accounts, 2 disputes arose. One, every material which the plaintiff had given to me, he put it to my account. 40% of the material was not to my account because I used it in the plaintiff's house. And secondly, he said, while issuing the money to the check to him, I said, please settle your account with me for the wood which I purchased and for the labor cost. And the plaintiff started raising all kinds of issues, and I therefore never issued the check in question to him. We have yet to settle the accounts, and he calls upon the court to the plaintiff to render the accounts so that they can settle the accounts. Now, this kind of a written statement on the pleas of avoidance would require the plaintiff to respond. Now, let's take the response of the plaintiff in the replication. He admits that the defendant had executed certain works in this house, but says that I have not accounted for that material which I issued to the defendant because I knew that that material was to my account. So at least on one point, the parties are at variance whether the material which the plaintiff claims to have supplied to the defendant, does it or does it not include the price of the material which the defendant claims he consumed at the plaintiff's house. The plaintiff now in the replication also admits that the defendant had executed some woodwork, but says that I will not pay him for the woodwork because it was very shoddily executed. I had to rip off the entire plywood and I had to get the work redone. Now, having admitted that the defendant executed some woodwork using his own wood in his house, he sets up the plea of avoidance, that it was shoddy work. This would require a sur-rejoinder from the defendant. Why? Because the plaintiff's plea of confession with avoidance in the replication required the defendant to reply to the plea of avoidance. Having understood this, what is the relevance of this in judgment writing? You cannot start, if somebody were to start writing a judgment in this case by saying case of the plaintiff, he starts picking up on the plaint, case of the defendant, then he will be floundering, because the case of the parties have emerged in the plaint, followed by the written statement, followed by the replication, followed by the sur-rejoinder, followed by the response to the sur-rejoinder. 5 pleadings settled. So please, the first thing you do, don't start narrating the pleadings in the plaint as they are. Don't start reciting the pleadings in the written statement and the replication as they are. Put them in the basket. Sieve them. As Lord Denning said, 80% of the pleadings are nothing but the riff-raff by the lawyers. And Lord Denning is an acclaimed judge for precise judgment writing. So if I would use the native expression, the Guru Dronacharya, the Bhisham Pitama of the art of judgment writing, cautions us, remove the riff-raff of the lawyers in the pleadings. Secondly, look at the pleadings and understand which of the 4 nature of the pleadings are we dealing with. In the illustrative case of the kind, the pleadings, the judgment should start, the dispute between the parties, or you would say the dispute between the plaintiff who is engaged in the business of a hardware merchant and the defendant who is a petty contractor is whether, as per the practice of the parties, where goods were received by the defendant for a period of 1 month on credit for the month of March 2020, demanding rupees 1 lakh as the price of the goods, were they all the goods which were used by the defendant to his own use for the reason the defendant claims that certain goods taken by him from the plaintiff's shop were used by him to the plaintiff's account by executing work in the plaintiff's house. The further dispute from the pleadings of the parties which emerges is that the works which the defendant carried out in the house of the plaintiff at the asking of the plaintiff using wood from his own resources were they of the required specifications and not warranting the plaintiff to remove them and redo it. Further, what is the money payable by the plaintiff to the defendant on account of the labor charges? Once you settle the pleadings like this, the issues can be crystallized. So the second stage of the judgment, if you would have said, as I said, these facts viewed in the context of this law. So when we say viewed in the context of this law, require the issues to be settled. The issues to be settled. How easy it would be then to settle the issue? The first issue would be, what is the value of the goods supplied by the plaintiff to the defendant to be used by the defendant to his own account? Question mark. OPP, onus on the plaintiff. Next, what is the value of the wood used by the defendant to execute repair works in the plaintiff's house? OPD. Next, whether the woodwork executed by the defendant in the plaintiff's house was not up to the mark, requiring the plaintiff to redo the entire work? Question mark. OPP, onus on the plaintiff. Next, what is the effect of the decision on issue number 2 and 3? Why? The effect would be, if the work is completely shoddy, then on issue number 2, the defendant loses. If it is not completely shoddy, plaintiff partly loses, the defendant partly wins. So the second stage of settlement of issues actually follows from a critical analysis of the stage 1 of the reading of the pleadings of the parties. So having understood the importance of pleadings and the initiation of the case of the parties, which is which you could call is the front page of the judgment, which we could call is the front page of the judgment, follows by the settlement of the issues, which is the second stage of the judgment. The third stage is the narration briefly of the evidence, documentary as well as ocular. Here, do not be verbose. As yesterday while speaking on cross-examination and witnesses speaking, I had brought out that not what all witnesses speak is relevant. It is only which damages the case of the other side which is relevant. So while narrating the deposition of the witnesses, be brief. Look at what is the nature of the evidence which probabilizes or deprobabilizes the existence of the fact. Only narrate that. Brief transcript of the documentary evidence, narrate that. That the plaintiff's witnesses have exhibited such and such exhibits, briefly what they are. So that would be a narration of the relevant facts. While doing this, you could at this stage intermingle what normally I find is a distinct part of the judgment, which unfortunately renders a judgment a little prolix. What you could do would be, if the plaintiff has examined 4 witnesses, Witness number 1 has deposed to a primary fact, to a fact relevant in issue in the nature of a conduct. Second witness has deposed to a fact in relation to conduct and a motive. The third witness has referred to a fact relating only to a motive. And a fourth witness has given an overall evidence. So while recording the testimonies and the evidence that at the trial this was led, link up the evidence of 1 with 2 in relation to the common features, 2 and 3 with relation to the common features, and 4 in relation to the overall view. Why? Because while reasoning, you would be able to package your evidence. We'll come to that part a little later. So if you merge while narrating the documentary and the ocular percipient evidence led by the parties, common features could be linked together in the narratives, because thereafter starts the soul of your judgment. The third part of the judgment is the judge's reasoning. Before he comes to the argumentative part of the reasoning, he must set the texture of the reasoning. It's like baking a cake. So what do? You take flour, you put it in a pan, then you put some butter in it, you may put some yeast in it, then you stir it, and you keep it aside for some time. Why? The yeast must ferment. Then you take, if you have to caramelize your cake, you take your pan and then you say you put your sugar and then you burn it a little, only till it turns golden brown or deep brown, depending on what level of caramelization you want. Then you put it on the side. So you have to make it a cream cake. Then you start whipping the cream. And you put your cream on the other side. And if you have to garnish it with some fresh fruits, then you cut your fruits and put them aside. Then after an hour, 1.5 hours, depending upon the recipe, you take the baking dish. Again, you put some butter. And if you have to caramelize your cake at the bottom, then what do? You caramelize it in the baking dish itself. So similarly, judgment is also like baking a cake. So comes the next part of the judgment, where you start analyzing the evidence. In this analysis of the evidence, what are you to do? You are supposed to package, as I said in the earlier part of my talk, different facets of the evidence relating to the same relevant issue. Meaning thereby, 2 witnesses have spoken of a motive, so you would refer to them together. So he may be PW2, the second may be PW16. Do not narrate PW1 said this, PW2, PW3, PW4, package. PW2 deposed about the motive saying this. PW16 also deposed of the motive saying this. At a civil trial, suppose it is an issue relating to delivery of goods. PW1, who is the transporter, deposed that he received a call from the plaintiff on such and such date, informing that please send a truck for delivery of the goods to the defendant's place at such and such. PW4 is the driver who's deposed that he was engaged as a driver by the plaintiff by PW1, and on such and such date he was instructed by PW1 to go to the plaintiff's factory informing that some goods have to be delivered. Then he says, I am a literate driver. He gave to me the office copy of the goods receipts. When I went there, I noted them in the so the quantity of the goods which were delivered to me, and I took it and delivered the goods. So see, PW1 and PW4 are correlated and interrelated witnesses. So at this stage, you start analyzing the relevance of the facts and the weightage. Because this would be the material on the basis of which you would author and pen in your judgment the conclusions you draw on the facts. Well, it is easy to note the facts which are relevant, which probabilize or which reprobabilize a fact in issue. It is also easy to note whether a relevant fact asserted has been proved or not proved. And for this, your guidance would be from the law of evidence. The first part from section 1 to 55 will guide you as to what are relevant facts. Section 56 to 100 would guide you on a proof of a fact. So if you land up with a dispute whether a fact has been proved, you could take guidance from section 56 to 100. And then 101 deal with production and effect. So in the judgment writing, the first part, whether a fact is relevant or not, you have got good guidance. Whether the fact is proved or not, you got good guidance. But the problem comes while reasoning the production and effect. Why? Because you have to write whether this evidence probabilizes or deprobabilizes a fact in issue. Now, what should be the degree of conviction required to be objectively stated to arrive at the conclusion? That is where the real problem lies. The judges indeed find it very difficult, and it indeed is a difficult task, that what should be the degree of conviction required to be objectively stated. Keep that. That subjectivity which is in your head has to be reflected objectively to arrive at the conclusion. Why do you believe this witness? Why are you not believing this witness? How can you do it objectively? With reference to past statements and conducts of witnesses, there may be slight variances in what they depose in court. So train yourself to look at the legal language used by courts. What are the legal language used by courts? Is this an improvement? And if it is, don't rest it at that. Is it a material improvement? So record it like that. Write truthfully. Yes, there is an improvement in the testimony of the witness vis-a-vis what he said earlier. But for this reason, it is not a material improvement. If it is a material improvement, is it fatal? Every material improvement would not be fatal. So you are judges. You have these tools in appreciation of evidence and statements. And don't leave it at that. Follow the logical statement. The witness is confronted with his previous statement. We find that there is an improvement. But this improvement is of a natural improvement. The reason being, witnesses don't know what to tell. They don't know what is relevant. The investigating officer at stage 1, while recording his 161 statement, was satisfied with some very brief statements made by him. But the prosecutor asked him questions in a little bit more detail. So he only amplified what he had said earlier. So amplification is not an improvement, much less a material improvement. Now, what would be a material improvement? The witness has said in his 161 statement that I was standing at the bus stop and there was a tea stall 50 meters away. An altercation took place at the tea stall and I saw A beating B. But while deposing in court, you were to say, after doing my job in the city, I was returning to my village, and as I got down from the bus on the main road, it was around 7:30 and the month happened to be December, and we all know at 7:30 in December it is dark. I thought, let me have a cup of tea, and then he says, I saw this fight, and now he introduces, in the light of a lamp in the shop or in the light of the street pole, I could see. But this witness, who had assisted the investigating officer in preparing the site plan has no lamp. And now he introduces this version because it has his compulsion, because in darkness, how could he see 50 meters away who's hitting whom until and unless the place was lit? So you must draw a distinction while narrating your facts. Now, why do I say this? The reason is the degree of conviction has to be objectively stated to arrive at the conclusion. And the problem is what? Since it's an incline, and we are all of us are understanding what inclines are, because every day in the evening when we watch our televisions, we are all keen to know whether the curve is flattening or not, or the corona curve is flattening or not. Similarly, while noting the weight of the evidence, to objectively state the conviction which the judge forms to draw the conclusion, obviously it's an incline. Now the problem is that the degree of conviction to be climbed to cross the incline must be such which silences doubts for practical purposes and not completely eliminate the doubts, for this is near impossible. It's a guiding factor which judges overlook. And therefore I took the trouble of actually writing it down. And I repeat once again, what is the linkage? The discussion of the evidence, the noting of the evidence in the judgment, we are talking of judgment writing. So when the judge is narrating the evidence, before he starts reasoning with the evidence, he must write it in a packaged manner, because while discussing, he must get a hyperlink to objectively state the reasons for the conviction for the conclusion. Then, since the degree of conviction is an incline, and there would be an element of subjectivity to say that now the incline has crossed over, do not labor to completely eliminate all doubts, because then your judgment will go circuitous, and at some stage you will land up disjunctive, and you would use what kinds of expressions? Be that as it may. You see it in large number of judgments authored by High Court judges, even by Supreme Court judges. They write some facts, they discuss it and say, be that as it may. Well, what do you mean, be that as it may? It's such a vague phrase. Never use be that as it may. It means you are laboring on your facts to reason to completely eliminate a doubt, which is near impossible. So what is required is to state your reasoning which silences doubt for practical purposes and not satisfy each and every doubting thumbs. Keep in mind that no code has, and none perhaps can specify, the standard of persuasion. Therefore, the weight of the relevant evidence must be brought out to bring home the point. What point? More likely than not. It must bring out more likely than not. While analyzing what actually happened on a particular occasion, how to do that? You have to compare the coherence of the particularistic evidence with the various causal theories which emerge. The more particularist the listing of the evidence, the greater the fit. But one has to be careful and avoid attributing a causal relationship based on spurious correlations. Now, maybe a little confusing to you, but I can make it simple. Let's take an example. If it is proved that every day, exactly 1 hour after A boards the bus from the bus stand near his house, B also boards the bus from the same bus stand to go to his office. Somebody would say, what is the causal connection? The causal connection is that 1 hour after A leaves the bus stand to go to his office, B leaves the same bus stand to go to his office. Now let's understand. There is no causal connection between A leaving and B leaving 1 hour after. The causal connection would be the office timing of A and the distance from the bus stop to A's office and the distance of B's office from the bus stand and the timing of B's office. If A's office starts at 10 and the journey time is 1 hour, so A will leave at 9. B's office is starting at 10:30 and is half the distance of the office of A. So therefore B leaves after 1 hour. So the misleading causal connection of B leaving because A leave is not there. The causal connection is the office timing of the two and the distance of their office from the bus stand. So keep that in mind. This is where the heart of your judgment is there. We are at the topic of judgment writing and not analysis and appreciation of evidence. So I bring you right back to judgment writing. So after you've written the versions of the two parties in the manner which I said, followed by listing of the issues which you have to decide. Third is the recording of the ocular and the documentary evidence. Don't be like a parrot, PW1, PW2, PW3, PW4, this document, package it. Package it. If similar facets of evidence have been deposed to by two witnesses, put them together. Put a witness, if witnesses may be overlapping, at least that kind of craftsmanship you have. Then comes the next stage of the judgment, which is extremely crucial, where the judge starts giving his reasoning. Then he starts analyzing. From the evidence, he sieves out that this is the package of the relevant evidence of motive, of conduct, of preparation, of conspiracy. This is the relevant evidence of recovery. These are the contradictions where recoveries are becoming doubtful. These are the contradictions where motives are becoming doubtful. So he must be fair. He must record the positive side. He must also record the analysis of the deprobabilize the negative side, and then state his conclusion on the facts. Immediately followed by the law. For example, in a criminal trial, the accused who has been charged for murder, the evidence through the testimony of the witnesses is emerging that it was upon the spur of the moment. So after recording the evidence, not simply that A attacked B and hit him, he must also record that it happened at the spur of the moment without any premeditation, and then he must say that the law attracted. Now I have to look at my section 299. I have to look at my section 300. I have to also look at the explanations to my section 300. I have to look at my section 304 as well. Yes, every manslaughter is not murder. It could be murder is culpable homicide amounting to murder, culpable homicide not amounting to murder. So he must record that. And then, since it is without a premeditation, he says this is culpable homicide in the application of the law. So the fourth limb of the judgment is the law which gets attracted. He said the law which gets attracted is the exception to and the explanation under section 300 of the Penal Code that this is culpable homicide not amounting to murder. And he has to further reason whether it is punishable under the first part of 304 or the second part of 304. Then he would say, what is the difference in the two? If it is with the knowledge that the death would ensue, then it is 304 part 2. If it was with the intention to so and so, then it would fall under 304 part 1. So kindly see that while narrating the facts, it has to be followed by which law gets attracted. Say, let's take a civil trial. Is it acquiescence which is emerging? Is it abandonment which is emerging? Is it estoppel which is emerging? All fall in a different context and a different category. This stage is then followed by the conclusions. The conclusions are the interface of the evidence with the law applicable to draw the conclusions. This becomes the structure of your judgment. I'll elaborate a little more. But be careful while using language. Highly charged language to characterize the party's position is actually a rhetoric weapon that often backfires. Because if your judgment is taken up in an appeal, it alienates the reader because the charged language is based or at least gives the impression of being based on passion rather than law. A judge's judgment is to be based on law and not on passion. Judges, when they rise above emotions, write judgments where the viewer is convinced that it is not a biased judgment. And bias doesn't mean a personal animosity. Bias has various forms and various features, and the underlying thread of every bias is that it kills or at least impedes impartiality. Now, with this framework, let us get into something more specific. Because part 2 and part 3 and part 4, which I have intermingled, need to be little bit separated while writing the judgment. Now, let's see what a judgment should include, followed by what a judgment should not include. After all, a judgment, as we said, is a statement of fact and the law applicable to arrive at a conclusion. Keep that sentence in mind. Keep that one sentence in mind. That how this one sentence is flowing like a flow chart. Now, what a judgment should include? A brief overview of the facts to set the scene. A succinct statement of the issues to foreshadow the structure. A succinct statement of procedural history, but only when it is relevant. Sometimes the procedural history may become relevant. For example, you may be wanting to decree the claim but deny interest pendent related. Then you must record that the suit was dismissed in default on account of the plaintiff taking no steps for serving the defendant. It took 2 years for the suit to be restored. Then the plaintiff took so many adjournments to lead his evidence. The defendant did not take any adjournment to lead his evidence, but for cross-examining the defendant's evidence. So that brief history only recorded if it is relevant, and you are going to use it for some purpose to deny a particular kind of a claim, which otherwise in law may be a sustainable claim. And this is important. An impartial statement of the losing party's position on each issue. We tend to give judgment to support the claim of a party. But the general trend world over is reason why the losing party has been declared to be the loser. So a clear impartial statement of the losing party's position, meaning thereby a judgment should not be why A wins, a judgment should be more styled why B loses. The approach should be that. Then a clear statement of the flaw in the losing party's position on each issue. Next, anything that influences the ruling. Anything which influences you, because that must be stated. Anything the losing or disappointed party reasonably thinks ought to have influenced the ruling. Anything about which an interested reader, including a tribunal, might reasonably be curious. Anything that, if omitted, would create an opportunity for an appeal. Evidence supporting findings on material facts. reference to any law, standard or fact upon which the judgment is based. What should the judgment leave out? Dates and details on which nothing turns. Extensive quoting of statutes and precedents that can be paraphrased. Patches of law that have no bearing on the case at hand. Repeated information. Tedious narration of the hearing. These have to be excluded. Why? Why is it so? Because there are certain basic principles which govern a judgment. What are those? First, clarity. Second, honesty to the cause of justice. Meaning thereby, in clarity, it means you have to read your material first. The pleadings, the evidence, there must be clarity. Honesty to the cause of judgment. Many a times we find a judge finds that if I have to decree the claim, I have to labor a lot. That's a hard work. But dismissing it is easy. So because a lot of riffraff I don't have to do. So it has to be honesty to the cause of justice. Courage. Why courage? Because a judge must write the order fearlessly, keeping in mind decency and decorum, without being browbeaten or overawed by the overzealous arguments advanced before him. Don't be scared that my judgment will go up in appeal. Have courage. Hard work I have already pointed out. And last is free from obstinacy and bias. Because these are the basic essential features and principles of a judgment. It must be contained. Do not use words, the meanings of which you don't know. It is called malpropism. Avoid malpropism. Do not use a word till you do not exactly know the meaning of the word. Just 5 more minutes. The distinction of in criminal and civil cases also must be kept in mind. In a civil case, there are pleadings. In a criminal case, there are no pleadings. In a civil case, you refer to the pleadings of both parties to extract the issues, but in a criminal judgment, you do not extract the issues, but you specify the offense for which the accused is charged of. And if you are convicting, you have to specify the offense for which you are convicting the accused. And with this backdrop, you would have found my webinar a little dry today. It had to be because the subject was a little dry, but I have tried to bring out the outflow. I have a PPT with respect to this. I would be forwarding that PPT to the Maharashtra Judicial Academy and with a request that they could share it with the other judicial academies as well. And I think it is time to throw open now for some questions. Thank you.
Thank you so much, sir. Sir, I would now request Nasir Hussain Jamadar sir to please ask questions that have already been received in the question and answer round.
Yeah.
And sir can answer those questions.
Yes. So, thank you, Chetan. My lord, we have received a few questions.
Yes.
So I will start putting the questions, my lord.
Mm-hmm.
The first question is, when section 354 of the Criminal Procedure Code provides that the judgment shall contain points for determination, the decision thereon, and the reasons. So, whether decision shall be followed by reasons or reasons shall be followed by decision.
Now let us understand. A decision is in a larger thing. When we talk of a decision, we mean the judgment. So I think I've already answered it. The person who's putting the question wanted to say that the conclusion, obviously the conclusion has to follow the reasons. You can't have execution first, sentence afterwards, judgment afterwards. So it's very, very simple. Reasons, conclusions must follow the reasons.
Yes, Lordship. Yes, Lordship. So I will take the next question, my lord. The question is, large number of authorities are submitted by advocates without mentioning the issue for which those are relied on. In such case, whether all authorities are required to be dealt with in the judgment.
Well, it is sad that lawyers do it. So truthfully, simply write the truth that learned counsel cited these judgments, but when called upon to show the relevance of any, failed to do so. Write it. But be truthful to the cause of justice. Be truthful to the cause of justice. Like, for example, a counsel has cited a judgment that, look, because of this conduct of the victim was disbelieved in this judgment. Because of this conduct of the witness, he was disbelieved. The prosecutor also cites some judgment, and you would see what the problem would be. In every judgment would see different people react in different ways in different circumstances. So neither becomes a precedent for the other. So just record. Learned counsel cited these judgments, and the principle of law is that depending upon a circumstance, different people react in a different way. And what I have to test is whether the person has reacted rationally. Now, let me give one illustration of a very interesting case with which I had dealt with. It was the rape case. It happened like this, that a medical intern student who had left her institution and had to cross a slightly secluded area of South Delhi where there were ruins was accosted by 4 people, and at the point of a knife she was raped. Immediately after she was raped, she went back to her hostel. She met a friend. Her friend said, "What happened? You look very disabled." She said, "I've been raped." Her friend was shocked. So her friend went out to get other friends. This girl just took a bath and she ran away. They couldn't locate her. When she was standing at the bus stop to go to her house, there was a policeman going by. He just saw, he's a good policeman. Normally police doesn't bother about it. He found that this girl was very perplexed. He asked her what went wrong. She said, "I've been raped." He took her to the police station nearby. He made her sit there. He went to the IO. He went to the SHO that this is what has happened. And the girl went away. Unfortunately, he didn't make an entry in the Roznamcha. Somewhere the information leaked out. No, sorry. That night, the girl with her parents came to a government hospital, LNJP hospital. So what are you here for? She said, "I was raped in the morning. I want my medical examination done." And before the lady doctor would come, she vanished. She vanished once again. But in the hospital record, she gave her name and her address. On the 4th day, somewhere the press got hold of it, and those headlines in Delhi papers. And ultimately, when the IO would go to a place where she was residing, her parents would say, "She's not here, she's not here." Ultimately, at the trial, what was argued? They look at her conduct. So she confides of rape and then she runs away. don't cite judgment. Here the argument was, this is not a rape victim acting in a consistent manner. They said her conduct is inconsistent. The trial court just noted some judgments. That was wrong. What did I write? I said, look here. Look at the psychology of a victim and a rape victim. How many feelings do creep into the head of this rape victim? Fear, anger, hatred, revenge, feeling of low esteem. It just depends which feeling overpowers you. At the first instance, what was the feeling in her? She felt dirty. Anger and revenge was there, but she was feeling dirty. So that feeling of being dirty overpowered her, which led her to her hostel. Then she finds a friend. She finds a comfort. Which feeling overtakes her? A feeling of wanting sympathy. She told her friend, look, this is what has happened with me. But as her friend went away, she was alone. Which feeling overpowered her? Shame in the Indian context, which led her to run away. When she saw the policeman in this cauldron, and the policeman asked her, which feeling overpowered her? Feeling of revenge. Justice, I must seek justice, which led her to there. And when she sat in the police station, and she got a moment to herself, another feeling overpowered her. What am I doing? In an Indian society, I'm an unmarried girl. I'll come in the press, everyone will know. She went away. In the house, she brooded. Again, she sought justice. She went back, meaning thereby, conduct which may apparently seem contradictory can be reconciled. Write it in your judgment. Next question.
Yes, thank you, my lord. The next question is on civil side. It says that notwithstanding a case may be disposed of on a preliminary issue, why the court shall pronounce judgment on all the issues?
It is like this. It's simply Order 14, Rule 2. Please read it. If on a preliminary issue, a case can be finally decided, you can decide it on the preliminary issue, though the requirement is of deciding all. So please look at Order 14, Rule 2 and decide. This is not a question we are discussing art of judgment writing and not whether I should decide a preliminary issue first or not. There are some guiding judgments. Please look at the judgments under Order 14, Rule 2.
Yes, Lordship. So I will take the next question, my lord. It says, is it necessary at all the times to narrate the facts of the citations relied upon by the parties or the judge himself in his judgment, or only quoting ratio laid down in the judgment is sufficient?
It is sufficient to cull out the ratio, but do not forget that many a times the ratio gets inextricably linked to the facts. Like, for example, the issue is whether A had abandoned his claim. Now, abandoning of a claim would be a matter of a fact and not really a pure matter of law. Now, what is abandonment? A conscious giving away. It is like this. I have this pen with me. One day I get fed up of this pen, though it's in a working condition. So I throw it in my dustbin. And next day morning, my domestic help gives it to the fellow who comes to collect garbage. That man looks at it, he says it's a good pen and he keeps it. And one fine day I find this guy is writing and using this pen. I said, listen, but this is my pen. You would say you abandoned it. Now, the guidance of this judgment would have no precedentiary value. It would have no precedentiary value. Now, what happens is a judgment would have a precedentiary value only on the law which it settles and not on anything else. So if the judgments are on fact based, you have not to note the facts. You simply say This is a fact-based judgment and it has no precedentiary value because I am deciding abandonment.
Thank you, Lordship. The next question is whether it is necessary to discuss motive in criminal judgment.
Well, every aspect which incriminates the accused has to be discussed. And if the prosecution alleges a motive, you have to discuss the motive. Let's understand that notwithstanding motive being treated to be a weaker evidence, in certain circumstances, it may be a very strong evidence. Why is motive treated to be a weaker evidence? Because on the theory of logic, it is based on a presumptive logic. What is the presumptive logic? Because A had the motive to do something, A may have done it. It is a presumptive logic. And presumptive logic obviously has two possibilities of error. The first possibility of error is that the taint in the evidence of the person who deposes to motive may be overlooked by the judge. The second taint would be the conclusion of the motive which the judge is drawing may be wrong. As distinct from a direct evidence, in a direct evidence, it has only one error. The judge may be wrong in believing the witness, or the judge may be wrong in disbelieving the witness. But if you believe a direct evidence witness, then the judge has to draw no further inferences because he says, I believe the witness. He draws no further inference. So coming back to your question, the answer is if motive is there, you have to discuss it, and because it has relevance.
Thank you, Lordship. Now I'll put the next question. Is it necessary to hear both parties before commencement of trial once again on issues to see if they have been properly framed or needs to be reframed?
It is like this, that you would see many a times that at the trial, parties give up some positions which they originally took. So in such a case, while hearing arguments, you tell the lawyer that, look, this issue got settled because this stand you took. But now while arguing, you are not taking this stand. So this issue becomes a non-issue. I will record that you never argued, or this issue you argued in this facet, or in evidence it has emerged in this facet. Therefore, I will reframe the issue. This takes place in a court of law during arguments and is reflected in the judgment. So a separate exercise of reframing the issues, resettling the issues need not be resorted to, but honestly reflect it in your judgments.
Yes, thank you, Lordship. The next question is, what is meant by and what is the importance of marshalling of evidence?
Marshalling of evidence means simply this. The troops are all called for the morning parade, and the parade has to start at 11 when the company commander reaches the flag at the dais where he takes the salute. So all the troops have assembled and they are loitering around. The company commander, like the marshal, he says, fall in line. Everybody gets up and they start arranging themselves in 3 straight lines. All of them have been told what their positions are. This is called marshalling of evidence. That the witnesses have deposed. Let us give an example. Witness 1 has deposed to the motive of the crime. He has also deposed to last seeing the victim in the presence of the accused. He is also a witness to a recovery of something from the house of the accused. The second witness is only a witness to a motive. The third is a witness to the last scene. The fourth is a witness to the recovery. The fifth is a witness that I saw all of them going towards the field. So they're all lying stewed over in the field. So while marshalling, you say the witness, so the judgment would be from the evidence on record and the case of the prosecution, the court has to determine whether the prosecution has established that the accused had a motive to kill the accused on account of the accused harboring a feeling in his mind that the accused harasses his sister. That is the motive. No direct evidence of anyone stabbing the victim by the accused has been seen, but there is a witness of a last scene. The recovery relates to the weapon of offense and some letters and messages exchanged between the sister of the accused and the deceased. So this material, which is the exchange of letters between the accused and the sister, between the deceased and the sister of the accused, of the witness will relate to motive, the other would relate to the weapon of offense. So marshalling means every strand, every log which would be used ultimately to craft the bridge has to be put in the sequence. That is marshalling. Yes, you have to marshal the evidence.
Yes. Thank you, Lordship. The next question is how to appreciate the judgment which is not cited by the advocate but important to court.
How to?
How to appreciate the judgment which is not cited by the advocate.
Okay. So yes, some lawyer has not cited a judgment, but that is within the judge's knowledge. Two things. If it was in his knowledge when the arguments were taking place, and he is culling out a legal principle to be used against one party, fairness demands that he could tell the lawyer that, look, Mr. Counsel, there is one judgment against you. Because many a times a small little fact here or there shifts the applicability of the judgment. But if it has emerged, no point to put it for re-arguments, then you simply use it, though not cited, but the actual principle of law is laid down in this judgment with this clarity, no harm. Do it. Judges do it.
Yes, Lordship. The next question is, can we use Latin maxims in the judgments?
The latest trend is write judgments in the parlance of what the common man understands. Don't try and make your judgment too flowery, but yes, Latin maxims can be used because they lay down some principles of law. But after using the Latin maxim, also narrate its actual meaning in a layman's language and how it applies.
Yes. My lord, the next question is it necessary to defer hearing on the sentence to a different date when a conviction is recorded against an accused under section 302 of Indian Penal Code, or it should be done on the same day and the sentence can be pronounced?
Look, in a case of murder, the judge can only do one of the two things: sentence him to death or sentence him to life. If he finds it's a case of an ordinary murder, where hardly any scope of a death sentence is attracted, and he's imposing the lesser one, then no harm. But if it is a life sentence intended with a minimum term before which remission can be considered, say 20, 25, 30 years, or a case bordering towards death sentence. It must be deferred for different considerations then come into play. Then some mitigating factors not towards conviction but towards the sentence. According to me, if there are more than one accused and other than murder, or even if there's a single accused for sentence, you must always give time so that the lawyer can come forward on the quantum of the sentence as well. Let me give an example. I dealt with one case. In a rural setting, at the exhortation of the father, the son did the stabbing. It was a case of 304 part 2. And normally you would say, he's the principal offender, I'll give him 7. This guy has exaltation, I'll give him less. But in a rural setting, if the son did not respond to the exaltation of his father, he would have been condemned in the society. So the graver role was of the exalter and lesser of the son, which the lawyer could bring out in his arguments. So it would be always advisable that even if it is a case where the judge in a 302 wants to give a life sentence, no harm, as they said, justice should not only be done, but should be manifestly seem to be done. And right to hearing has been incorporated in our system, though the effect of the hearing may be nil, but denial of a natural justice is a wrong in itself. I would advise all judges in criminal matters to defer a sentence and give a date for hearing arguments on sentence.
Thank you, my lord. One related question there too. How to draw a balance sheet of mitigating and aggravating circumstances while imposing death penalty after recording conviction?
I have tried to make a balance sheet, as a balance sheet is actually to be done in one of the judgments authored by me in the Delhi High Court. And there are at least 20 mitigating and 20 non-mitigating circumstances. I do not recollect them offhand, but if you, I think the judgment would be any time between the year 2000 and around 9 to 2011. So if you could access the Delhi High Court website, you just feed in my name. I have listed out, I've attempted to say a balance sheet, because what had happened was the Supreme Court repeatedly had been saying balance sheet, balance sheet, balance sheet, balance sheet, but then how to make the balance sheet. So I looked at some judgments where I said this was considered mitigating, this was considered mitigating. So I noted the judgments and I drew the debit and the credit side of it.
Yes, Lordship. This is related to the earlier question. So at that stage, means at the stage of considering these mitigating and aggravating circumstances, is it necessary for the accused to put in his written submissions on the point of sentence, and his examination by the court is necessary?
No, not at all.
So I will put a next question. Is it required of a trial court to reproduce the evidence or translation thereof, if not recorded in English, of the witnesses in the judgment?
No, you see, as I said, you broadly, you narrate their testimony in your judgment. But if it becomes sometimes essential to exactly quote, because the idiom of a sentence cannot be brought out on a translation. It cannot be brought out on a translation. Then you must exactly use and record that word as it is, and in English transliterated. Transliterated. Like for example, when we say provocative words, in different societies, different cultures. Like for example, I come from Punjab. So, for somebody making an innocent mistake lovingly, so many times elders in the family says, "Oh, tu in Punjabi khote wali gal kiti hai tu. You behave like a donkey." I'll feel very proud if my elder tells me, "Tu khota hai." I'll be very happy because he's loving me. But maybe in some place it may be treated to be something very, very offensive. So as a matter of rule, if you are translating it, transcribing it, it is sufficient. But if a particular word in its textual setting assumes importance, then it should be recorded and it should be penned down, extracted, cut, copied and pasted.
Yes, Lordship. Thank you, Lordship. The next question is, can a criminal judgment dictated in open court and not signed can be recalled and substituted with another one with the consent of public prosecutor and defense counsel?
Whether it is criminal or civil, till a judge has not signed a judgment, it ceases to be a judgment. After you have dictated the judgment, and while correcting the judgment, you find that while narrating the judgment, you have reproduced a fact little incoherently, and you pick up your file to read that testimony, to state that fact in a very coherent manner, and then you suddenly realize that the immediate preceding two sentences or the immediate succeeding two sentences were overlooked by you. And they have a totally different bearing. Though rarely, I've also done it. Then you fix your case in the cause list under the caption of for directions, call the parties and tell them that look, and record in the order that last evening I had dictated it, but while correcting it, I looked at it, this is what has emerged, and I am putting it for further arguments. Follow the procedure of transparency. That is why I had, while talking about judgments, I had brought out this aspect of the matter, that the judgment should be honest and free from obstinacy and bias. So all these questions get answered when if the viewer has understood why I said what are the underlying principles behind a judgment.
Yes, Lordship. Lordship, the next question is, it is said that on similar facts in issue, there may be different reasoning and conclusion. What should the judicial officer do to ensure uniformity in it?
I would not disagree. I would disagree with this question put so widely. The manner of discussion may vary, and which may apparently give you an idea of the judgment being totally differently written. Maybe totally different written. But if you would re-paraphrase the judgments, you would find the same thing written at different places in a different manner. That is why in my talk today, I brought out list evidence of same features in different compartments, and in fact the phraseology used in the judgment writing skills at the Judicial Academy at Halifax is what they use the word, but I didn't use it because I thought that this is aggressive language. things like bullet point, shotguns. This is not good language according to me, but they said arrange the analysis of issues like rooms in a shotgun house. So I use the word package it. Now, how do you package it? And you said marshalling, packaging, marshalling, they are all complementary and supplementary to each other. So the only way is witness to the conduct, package it, witness to a motive, package it, witness to a last scene, package it, witness to an arrest, package him, witness to a disclosure, package him, witness to a recovery, package him, witness of medical evidence of forensic expert, package it. And please package them. Now I can't tell a judge that package motive first or package preparation first, but it should be done. Why? Because motive triggers the crime. So discuss motive first. After motive, you prepare for the crime. What is the harm if discussing preparation next? Pursuant to preparation, what do? You go to the place where you have to commit the crime. So witnesses of last scene, witnesses of running away, witnesses of that, put them. Then comes arrest. So if you could follow that sequence, I think all judges' judgments would be just in the same manner, and there would be greater uniformity and greater clarity. Similarly, at the civil trials.
Yes, Lordship. I will put the next question. Can an appellate court pass adverse comments on the trial court judge on his judgment in the appeal judgment without giving an opportunity to him to explain?
Look, adverse comment upon a person is one thing. Adverse comment upon your work is another thing. So if I find that you've done a shoddy job, what else do? I would say that this judgment crafted by the trial judge is a shoddy judgment. But I should not pass comments. It is reflective of a lazy judge. It is reflective of a judge who doesn't understand any law. It is reflective of lack of any understanding. Those condemned words which are personal to the author should be avoided. But it is the job of the appellate court to reflect upon the judgment and comment upon the judgment, as it is the same issue which judges say to the citizens, you may please criticize my judgment, but don't attribute personal motives. Say anything about my judgment, I have no issues. So the answer is simple. The appellate court should not make personal comments targeting the author. You may make any comment relating to the work. Authorship not to be disabused. The work authored anything, but be temperate still.
Yes, Lordship. The next question is, how points for determination in civil appeal and criminal trial will be framed, and answer by court? Is there any difference between point for determination and ingredients of offense and issue in civil?
No, they all are the same facets of the same thing. At base, the purpose of my talk was to bring home one. That in a civil matter, state the pleadings on the facts on which the parties are at variance clearly. At the criminal trial, you have no pleadings. State clearly what is the accused charged of. Then, at the civil trial, from the pleadings of the parties, issues of law and issues of fact to be stated. But in the criminal trial, issues are not settled, but the discussion of the evidence applicable to what offense is committed. For example, there's a difference between theft and criminal misappropriation. There's a big difference between the two. There's a big difference between culpable homicide amounting to murder, culpable homicide not amounting to murder. culpable homicide not amounting to murder, punishable under 304 Part 1 or 304 Part 2. So these marshalling, the judges must understand. What we are talking was marshalling of the evidence where a different facet of the evidence. And that will take us to the first webinar of mine. All relevance of facts is found under section 5 to section 56 of the Evidence Act. So two witnesses have deposed to res gestae. They may be 1 and 20, say they are res gestae. Two witnesses have deposed to previous statements made by the witness. They are relating to an admission under section 18. So therefore, that is what is needed. It is something like when you play rummy, don't you do that? You put all your spades at one place, you put your hearts at one place, and you don't have all your cards lying at random. That's what you do.
Yes, Lordship. The next question is it a good practice to open the judgment by writing the conclusion and then writing the facts of the case and then the reasons for such conclusion?
Well, the theory behind a judgment is that the reasons must flow and reach the conclusion. But no harm in saying at the beginning to the reader, issue number 1 is this against the plaintiff, issue number so and so against the defendant, followed by a discussion and the reasoning. So what you are showing is that you are not given the decision at the thing, you have just stated the tail end of your decision at the top. No harm in doing it, but well, it is inconsequential according to me, irrelevant, whether you do it or you don't do it.
Thank you, Lordship. The next question is related to case under section 138 of the Negotiable Instruments Act. The question is how and in what manner to appreciate the defense taken by the drawer to the check, and connected thereto, can a conviction and sentence in a summary trial be pronounced in the absence of the accused, related to 138 matter?
Now relating to, we are discussing judgment writing, so I would only answer this question on the judgment writing part of it, and not the viewers must also train their mind that what are they to learn today and have they learned today. When people ask questions outside the topic of discussion, the person who's speaking gets the impression that the viewer is not alive. Now, it is very simple that law says that a check issued will be presumed to be for consideration. So the plaintiff, the person who has lodged the complaint, that is the complainant, has the advantage of the presumption in his favor. That's all. Now, every evidence which dispels this presumption on the defense taken. So the task of the judge is very simple. That has this presumption in favor of the complainant being repelled from the evidence on record, which is led by the defendant to waive the presumption. And then in what manner, it's not possible, because wide and varied defenses can be taken. I can take a defense like this, that look, I am a businessman, I'm a small businessman, I have to go out from my office many times to do this purchase, that purchase, go and get the goods released from the railway authorities. I have to go to the tax authorities, sales tax authorities, I have to go to the income tax authorities, I have to visit the municipalities for so many works. And therefore, I always keep 2 or 3 checks signed blank in my office, and I entrust it to my peon and say that I issue a check once every 3-4 days. And then you say that, oh, one fine day when I opened, I realized one of my check was missing. And the defense evidence is that you have lodged a police complaint, and which is preceding the date on which the check has been issued by you. This is good evidence. that it got stolen, and then they say that I have cross-examined the complainant. What did I issue the check for? He says it was for a friendly loan. Where is the loan? I asked him, have you shown it in your books of accounts? I haven't shown it in my books of account. So you see, that will depend on the nature of the defense taken and the nature of the evidence led by the complainant then to show that the check was for a consideration.
Yes, Lordship. Almost all the questions my Lord has covered in the address as well as in question answers session. So the question answer session would end here.
Thank you.
So let me allow me, my Lord, to express the words of gratitude. Thank you. Here we have come to an end of today's webinar. Honorable Lordship has highlighted on the form of judgment and the essential requirements thereof, both for civil side and criminal side. A clear message from Lordship to not to narrate pleading as it is. Lordship has also guided us on how to frame issues and how to show onus thereof and how to appreciate the evidence. Yes, judgment is like baking a cake. Use legal language. Reasoning is the heart of the judgment. What Lordship emphasizes is that the conclusion must be connected to your reasoning. What a judgment should and should not include, that has also been mentioned by the Honorable Lordship. I sincerely thank Honorable Lordship for enlightening us on the very important topic of judgment writing. It was a mesmerizing experience. Thank you, my Lord. I also express my sincere thanks to the Honorable the Chief Justice, Bombay High Court, Chairman and Patron-in-Chief of the Maharashtra Judicial Academy, Honorable Director of the Maharashtra Judicial Academy, Honorable Lordships, Ladyships attending the webinar, Honorable Judges from Sri Lanka and Kenya, Honorable Registrar General, Registrars and Judicial Officers of the Registry, Bombay High Court and other High Courts, Honorable Principal Judges, my brother and sister judges from all over India and my colleagues in the Maharashtra Judicial Academy, our master trainers and the support staff who helped the officers in joining the webinar, the judges who raised the questions, and the SCC online team, Shri Suman Malik, Shri Sanjay Kapoor, and my co-host Shri Chetan Singh for providing this platform and making these webinars a continuous success. Thank you very much and have a great time. Thank you, my Lord.
Thank you, sir. Thank you, Nasir Hussain Jamadar, sir. Thank you, my Lordship. There's a small message to everyone who has joined today. First of all, thanks on behalf of SCC Online family. This, for members who have not joined in today, could not join in because I was getting a lot of messages. This link would be valid. So if you click on this link after this webinar is over, it will do a repeat telecast for you. So you can also view it later on. On that note, I will take a leave. And thank you everyone for joining us. We'll see you next time. Thank you.
Thank you. Thank you.